Good evening, ladies and gentlemen, esteemed guests, respected dignitaries, participants, and all those joining us from across the globe. A very warm welcome to the fifth Virtual International Mediation Competition 2025, an initiative by Mediate Guru in collaboration with APIIT Law School. This prestigious event, bringing together brilliant legal minds from around the world, is made possible with the generous support of Equilaw Partners and Hammurabi and Solomon Partners. Now, before we begin, it is my honor to introduce the distinguished dignitaries gracing this inaugural ceremony with their presence. Our chief guest, Honorable Justice Mr. Ajay Rastogi, former judge of Supreme Court of India. Our guest of honor, Mr. Jyoti Kumar Chaudhary, partner at Hammurabi and Solomon Partners. Another guest of honor, Mr. Joe Terrado, an esteemed international arbitrator, mediator, and ADR consultant. Our opening speaker, Mr. Praveen Mahajan, principal partner at Equilaw Partners. And of course, the visionary behind Mediate Guru, our host, Mr. Param Bhamra, founding partner at Mediate Guru. We also extend our gratitude to Ms. Garima Rana, senior partner at Mediate Guru, who will deliver the vote of thanks later in the program. I welcome you all to the fifth Virtual International Mediation Competition 2025. I now invite the driving force behind this competition, the founding partner at Mediate Guru, Mr. Param Bhamra, to formally welcome our guests and participants.
Thank you so much, Anisha, for for kicking us off. I'm very happy and delighted to be here and to welcome all the participants, all the expert assessors of the event, as well as our honorable dignitaries of the inaugural ceremony. And on the very outset, I would like to welcome Mr. Praveen Mahajan, sir. Thank you so much for your support. I would also like to welcome Mr. Jyoti Kumar Chaudhary, sir. We are very honored to receive the support. I would also like to welcome Mr. Joe Terrado, who I have the pleasure of calling a friend. And I'd also like to welcome our honorable chief guest, Mr. Justice Mr. Ajay Rastogi, sir. Thank you so much for accepting our invitation and being here and sharing your insight with all the students. And now I'm aware you all are here despite of your busy schedules on a weekday. And for that, again, I'm very grateful. At Mediate Guru, our vision has always been to further the cause of mediation and ensure that at least the upcoming generation of legal professionals are open to mediation rather than just looking towards the adversarial system of dispute resolution. And in that spirit, you know, we do these sort of events, we do conferences, webinars, just so that the upcoming generation could have a better hand than hopefully we got when we graduated. And I'll just like to mention that this thing has been told to me by a friend of mine, who I consider as my mentor as well. That is, if you are a lawyer, as a lawyer, parties won't come to you to get a landmark judgment. Parties won't come to you to, have the most persuasive argument ever. They'll come to you to get a solution for the problem they are facing, which I personally think that mediation can deliver. And now I know my job here is just to welcome the guests, but I'll just like to give a bit of advice to all the participants that it's not always about winning the competitions. It's about the journey as well, all the important things you'll learn. And don't forget to network. Try to engage in conversation where they are like-minded people. And I hope that you all have a fun time during the competition. Thank you so much.
Thank you, Mr. Bhamra, for setting the tone for this exciting event. Next, I would like to invite Mr. Praveen Mahajan, Principal Partner at Law Partners, to share his thoughts and officially mark the beginning of the competition with his opening remarks.
First of all, very warm welcome to the distinguished judges, a very talented pool of participants, and of course, the incredible team of Mediate Guru behind this event. It is indeed my privilege to be here at the 5th Virtual International Mediation Competition. It is true honor to have our chief guest, Honorable Justice Mr. Ajay Rastogi, former Judge of Supreme Court of India, whose contribution to the legal field have left a lasting impact on the Indian judiciary. Sir, your presence today elevates this competition and provides an incredible learning opportunity to all the participants, including even the judges. I must say at the outset that this event has grown in prestige and impact over the years. As the principal partner at the Equila Partners, we are proud to facilitate this initiative and witness the next generation of legal professionals to hone their skills in the field of ADR. I would like to sincerely acknowledge the presence of esteemed judges, Mr. Joy and Mr. Jyoti Kumar, who bring their vast expertise and experience to this competition, which would bound to make it more impactful. Furthermore, a special mention must be made to the Mediate Guru and Mr. Param Bhamra for their relentless efforts in organizing this event. Their commitment to fostering mediation as a core legal practice is really commendable, and it is through such efforts that we see a real transformation in the way disputes are resolved in the coming future, for making a platform for the students and even for the practitioners from various national and international universities and arena to present their talent. At the Equila Partners, we firmly believe in the responsibility of established legal professionals to create opportunities for the next generation. Our firm has always championed various initiatives that bridges the gap between the academic learning and real-world legal practices. That is why we are pleased to offer the deep internships to the talented participants of this competition at our Delhi office, allowing and presenting them with a well-diverse opportunity to gain hands-on experience in a dynamic legal environment. This competition really presents the fields of ADR, which is no longer just an alternative but an imperative branch of law now. The traditional adversarial approach to the dispute resolution gives way to more collaborative and pragmatic solutions, and mediation stands at the forefront of this evolution. In an era where time and efficiency dictate success, the ability to resolve disputes amicably and effectively is an invaluable skill. Tomorrow's legal professionals must be equipped with the expertise to mediate and negotiate, as these skills will define the future of law and justice. As we embark on the journey over the next few days, I encourage every participant to embrace this opportunity wholeheartedly, engage, learn, and most importantly, enjoy the process irrespective of the outcome. The future of legal practice belongs to those who can adopt, innovate, and resolve. And today, you take a significant step in that direction. Once again, I appreciate all who have made this event possible. A very good luck to all participants, and let's the competition begin with all its glory. Thanks a lot.
Thank you so much, sir.
Thank you, sir. Your insights were truly valuable. Moving forward, we are honored to have Mr. Jyoti Kumar Chaudhary, partner at Hammurabi and Solomon Partners, as one of our distinguished guests of honor. I invite him to share his insights on the role of mediation in today's global legal landscape.
Thank you, Anisha. Honorable Justice Rastogi, Mr. Joe Tirado, Mr. Praveen Mahajan, Mr. Param Bhamra, and the colleagues and the students who are there listening to us. Thank you so much for having me over on this very enlightening journey. And as Anisha has asked, called for me to address on the significance of mediation. If I take a journey or travel back to my memory lane. Those earlier days, in my earlier practicing days, Section 89 of CPC used to be the provision where judges would often say that why don't you go to have something out of the court's settlement or out of the court proceedings, maybe arbitration or mediation. Thereafter, I saw many mediation centers at many courts in Delhi, maybe Tis Hazari, uh, Patiala House courts, then Delhi High Court having its own mediation center. Over a period of time, it actually uh, got a very improved, even facelift as well. And then I saw era when mediators were getting trained. These developments I saw actually over a period of time. And during those days, as Justice Rastogi was also mentioning earlier, that only family disputes were principally being resolved in that, maybe a matrimonial disputes or property disputes among families and all. Over a period of time, we saw mediation going into resolving commercial issues as well, commercial disputes as well. And then we saw Commercial Courts Act rolling down, which provided for compulsory mediation, mandatory mediation prior to initiation of court proceedings. So, and then 8 years down the line, we saw Mediation Act 2023 coming up in full force with process and procedure prescriptions for enforcement of mediation settlement awards as well. So while we saw all these things, immediately thereafter came upon uh, a framework for use of mediation in the IBC proceedings. So that is the journey that mediation is now taking forth. Well, mediation is essentially an in personam proceeding. But the way we are dealing with it and we are trying to implement it in the IBC, it is going in rem as well. I mean, in the proceedings which are actually having a public nature. So, I mean, when we see the mediation process being implemented in IBC, I mean, I would just want to elaborate a bit how that process, I mean, could be introduced and how it is being seen. What we have seen as of now since 2016, pursuant to implementing the IBC, Insolvency and Bankruptcy Code, we saw a good amount of debt resolution, about more than 3 lakhs crores and still counting. We are yet to see an encouraging number of insolvency resolutions. So therefore, we are now talking about pre-insolvency phases, or whether there should be a pre-insolvency phase and thereafter there should be insolvency phase. So mediation can be a very good aspect to sieve away debt resolutions from the insolvency resolutions. I must highlight here, debt resolution essentially would mean a case where there is ability to pay, but unwillingness to pay. However, because of the processes of insolvency and all, a party may end up paying up. Or maybe by use of mediation, both the parties may agree to pay up and resolve the dispute, the debt. So if those debt resolutions are taken care of, then our actual insolvency resolution will be less burdened. Our NCLTs will be less burdened. Authorities will be less burdened. And there can be effective use of machinery, the ecosystem of insolvency towards actually resolving, towards actually achieving insolvency resolutions. So mediation with respect to that, I mean, has a special significance even in insolvency matters, which are sorry, which are the insolvency processes which are actually in rem proceedings, but then we are trying to make use of in personam processes in that in rem proceedings. So yes, it will be very, very interesting and learning process, and I mean enlightening to understand the as the competition unfolds, to get the the inputs from the students and inputs from the participants as well. So I'm looking forward to have an enjoying journey. Thank you so much for having me over.
Thank you so much, sir. Your description of mediation's journey was truly enlightening. Next, it is our privilege to hear from an eminent personality in the ADR world, Mr. Joe Tirado, international arbitrator, mediator, and ADR consultant. His expertise and contributions to the dispute resolution are invaluable, and we eagerly look forward to his thoughts on evolving field of mediation.
Thank you, Anisha, for that very kind introduction. I hope you can hear me okay. Good. Well, first of all, let me start, of course, by thanking, as you said, the force behind all of this, Mr. Param Bramra, and Mediate Guru for the invitation to participate today in this inaugural ceremony, along with such distinguished colleagues. It's truly an honor and a privilege to join you today. I also wish to commend, if I may, in the short time that I have available, Param and his fellow founding partner at Mediate Guru, Aditya Mathur, and senior partner Garima Rana, and all the team at Mediate Guru for their excellent work since establishing Mediate Guru just a few years ago, although it already feels that they've been around for quite a long time, in spreading awareness of mediation, fulfilling their stated aim of helping those who are lost to find their way and claim their right to justice. A very, I think, truly laudable ambition. It's also truly an international endeavor, and I'm extremely impressed by Mediate Guru's extensive network of contacts, and I'm delighted to see in particular the participation of teams from outside India, truly, or of both sides of the world. So that is a fantastic testament. I also want to particularly give my thanks to those who are participating in the competition, the students, because they are effectively helping in this aim. And really, I think it's through education that we're going to be able to begin to change mindsets. At the risk of being slightly provocative, but hopefully it will stimulate some debate and thought. I think for too long we've accepted the false premise that mediation is the alternative to litigation or arbitration. In my humble opinion, I think the reality is the other way around. That's to say that litigation or arbitration, they're the alternative to mediation. And I don't say that lightly. I think it's hopefully self-evident. All of us mediate all the time at home, at work, with our neighbors, our friends, day-to-day dealings with others, when we're acquiring goods and services. So whether it involves negotiating a suitable outcome when an issue or a problem arises, or whether we are helping others to resolve their dispute, the truth is mediation is the default, and I would say perhaps the more natural form of dispute resolution, and is not the exception or the alternative. And then, with all due respect to members of the judiciary who are with us today, I think rather than disputants having decisions, whether in the form of a judgment or an award, imposed on them by a judge or arbitral tribunal, mediation gives people in conflict the opportunity to negotiate with, of course, the assistance of a neutral, impartial facilitator, thereby making them the builders and architects of their own consensual dispute resolution. And I think it's that ability to reach creative solution beyond the usual binary outcome of win or lose in a litigation or arbitration, those solutions that are focused on parties' interests rather than their strict legal rights, is truly a powerful advantage of mediation that not only has the ability to resolve the dispute in hand, but also possibly other disputes between the parties that may be lurking there in the shadows, or potential disputes that may be coming down the road. I think having those type of creative solutions also minimizes the enforcement risks that exists in any negotiated outcome, because it's a resolution by the parties themselves. So I think, far from being the poor and weaker relation to litigation and arbitration, mediation has its own superpower and is able to do things that other forms of dispute resolution cannot match. I think the change in the current status quo requires a change in culture. This is, as we were discussing previously, before joining the call, this is a process it's not a switch. It takes time, sometimes a frustratingly long time, and it requires, I think, the commitment of all the stakeholders for it to really to progress, and particularly quickly. So the parties, obviously, council, courts, government, and educational establishments. And I mean right from the beginning, from elementary school to university, and in the commercial context in which I typically operate, I think this needs to involve management and business schools and chambers of commerce, not just law schools and bar organizations. We all have a part to play, and I think particularly the students participating in this competition are important actors in this move to change the current dispute resolution culture, and they are the ambassadors of change going forward. Let me just conclude, if I may, by reading a declaration that just literally, fortuitous, came to my attention overnight last night. Some of you may already know it, but it's known as the Edinburgh Declaration. It was signed following a meeting of a very prestigious organization known as the International Academy of Mediators back in 2018. It was following a meeting attended by nearly 120 mediators from over 20 countries who shared deep discussions about how mediators can look forward and work towards a new enlightenment, as they put it. Nearly 100 of those in attendance signed a declaration, now known as the Edinburgh Declaration, setting out what they believe in and commit to, emphasizing the value of principled and interest-based negotiation. I thought there's an initiative to kind of relaunch this declaration, but I thought it's very short, so please bear with me. I wanted to read it to you because I think it gives great food for thought. And I just wanted to share. So the declaration is this. It says, we, mediators, believe that it is in the interest of our world as a whole and our own communities in particular that difficult issues are discussed with civility and dignity. We believe that it is very important to find common ground and shared interests whenever possible, and to enable and encourage people to work out difficult issues constructively and cooperatively. We believe that finding common ground and shared interests requires meaningful and serious dialogue, which requires significant commitment from all concerned. We believe that understanding underlying values and addressing fundamental needs is usually necessary to generate long-term sustainable outcomes. We believe that restoring decision-making and autonomy wherever possible to the people who are most affected in difficult situations lies at the heart of good problem solving. We believe that mediators have a unique role to play in helping to promote the principles we have set out above. We believe that it is a privilege to act as mediators in a wide range of difficult situations in our countries, communities, and the world as a whole. We are committed to offering our services to help those in difficult situations in our countries and communities and in the world as a whole to deal with and resolve these for themselves in a constructive and cooperative way. We are committed to doing all we can to maintain our independence and impartiality in those situations in which we are invited to act as mediators and to build trust in our work as mediators. We acknowledge and accept that preserving our independence and impartiality in such situations may mean that any outcome reached may not accord with views or wishes we may hold as individuals. And we acknowledge that applying these ideas is a long-term, subtle, and complex process which we need to approach with humility, and the range of outcomes is possible in the many different contexts and places in which we work. We are committed to maintaining and raising professional standards through training, continuing development, and sharing of best practice. And coming towards an end, we recognize that it is important to exemplify the values that we seek to encourage, and in our work as mediators, we undertake to do our best and to encourage others to do their best too. 1, show respect and courtesy towards all those who are engaged in difficult conversation, whatever views they hold. 2, enable others to express emotion where they may be necessary as part of any difficult conversation. 3, acknowledge that there are many differing, deeply held and valid points of view. 4, listen carefully to all points of view and seek fully to understand what concerns and motivates those with differing views. Use language carefully and avoid personal or other remarks which might cause unnecessary offense. Finally, look for good common ground wherever possible. That's the end of the declaration. It is short. I invite you to reread it. in your own at your own leisure. It's a seminal, inspirational expression of belief, I think, and commitment by the international mediators, and it explains why we mediate, something that is rarely publicly expressed. And as the authors themselves acknowledge, no such document is ever perfect, and it would be understandable. That's my time up, I think, for there to be a few reservations about some of the expressions used. But overall, I think the declaration was certainly received with emphatic support at the time back at the conference in 2018. And I think, given where we are in the world now, we're at a time when the world feels increasingly uncertain. I think this is a meaningful opportunity to reaffirm those shared values and vision. So I think my time is out. Thank you very much for indulging me. I hope you found that helpful. And I just wanted to conclude by wishing all the teams all the very best of luck in the competition. And very importantly, to echo the words that my colleagues have already said, please enjoy yourselves. Thank you.
Thank you, sir, for such a compelling and insightful account of mediation process and its current progression in the contemporary times. And now, the moment we have all been waiting for, the keynote address by our esteemed chief guest, Honorable Justice Mr. Ajay Rastogi, former judge of Supreme Court of India. His words of wisdom and vast judicial experience will undoubtedly inspire us all.
Thank you very much for giving this opportunity, at least to share my views with those all legal luminaries in front of me. Mr. Praveen Mahajan, I know you well, you are a good advocate running so much. I'm proud of you. People like you are in the profession. Jyoti Kumar, I have not met you earlier, but I know you well of your practicing skills in profession. Mr. Joe, I'm meeting for the first time, but the view which you expressed, I fully endorse that the time has come when mediation will take place and all the commercial, this litigation, regular litigation, which you call a traditional litigation of your courts, will completely take a backseat in times to come. And last but not the least, mediate guru. I don't know why he's called mediate guru. Is a challenge of mediation, or he's a pioneer of mediation. But his working, I have seen, is much to be appreciated. Anisha, you're good. The way you have conducted the whole this program, you also deserve congratulations from me. And first, distinguished guests who have joined, legal professionals and fellow students of justice. Today, I stand before you to speak about a transformative approach to dispute resolution that has the potential to revolutionize our justice system, that is mediation. With the enactment of the Mediation Act 23, India has taken a historic step toward institutionalizing and promoting mediation as a preferred method of resolving disputes. We have a promise to mediation under the Act of 23. Mediation represents a paradigm shift in how we approach conflicts, unlike traditional litigation, which often results in protracted battles with winners and losers. Mediation empowers parties to craft their own solution with the assistance of a neutral third party. This collaborative approach not only preserves relationships, but also leads to more sustainable and satisfying outcomes. This moot court competition on mediation is a mock trial where participants engage in a mediation process rather than a traditional courtroom trial. In this competition, teams or individuals simulate the role of lawyers, clients, or mediators with the goal of resolving a dispute through negotiation and collaboration rather than litigation. Mediation is a form of alternative dispute resolution that focuses on peaceful negotiation and mutual agreement between parties with the help of a neutral mediator. If I go back to our country 100, 200 years back, we have a system in rural area of panchayat. And panchayat is a reform, this mediation is a reform of that panchayat solution system. when there was a mediator, a neutral person who was respected in the society, parties come to panchayat, put their grievances before him. He resolved with the consensus of the parties and giving his verdict, which was acceptable to the parties without any personal reservations. Now the mediation has taken, with the requirement of time, change of mindset, change of solutions, complexity of issues, putting it institutionalization. I go back to the time when the mediation was introduced, as you said, Mr. Chaudhary, in 2002 by Act of Section 89. Every time people were raising a voice that please institutionalize mediation. Otherwise, it was not working. Mediators are there, mediation centers are being opened, every state legal service authority are opening mediation centers. I am also proud to say I'm a trained mediator in 2010. As a sitting judge of Rajasthan High Court, I got mediation training, and I just want to share my view that time. When I was told by the trained mediators came from Delhi, sir, better you take mediation training with me. My view was, what kind of a mediation training you are giving it to me now, after almost 30 years being in judicial working. So after going through that mediation training, I find myself a great change. As Joe has said about your personal relations, your family, your neighbors, your well-wishers, and the person to whom you trust, you find a change in approach of yourself. So my request, one thing is, every one of us must take mediation training and participate in the mediation process. That will give a different outlook to resolving the disputes coming to your offices as in litigation. You see, people say it's an alternative dispute in resolving as an ADR. I said no. My experience shows, I came in profession in 82. There was a pendency in courts. 2004, I became a judge. There was a pendency in courts. 2023, I retired to the Supreme Court. There is a pendency in court. And I share my experience. I have attended myself number of symposiums, seminars at every level, how to curb and control this long pendency. Pendency has not controlled. When I came to Supreme Court in 2018, the pendency was hovering about 65,000. I left in 23. Now it is 83,000 pendency in the Supreme Court. People say that there is a trust in the institution. That's why the pendency is growing up. I said, no. People have no option. They can't hit the wall. Executive is not listening to them. They have no other forum to go. They say, all right, let me take a chance and find out whatever the way possible. So my view is now, mediation will take a front seat in resolving these disputes. We are introducing in commercial matters only for one reason, that parties should come forward with open mind, with no reservation, to consider as to what is my actual real dispute with the person in getting it resolved. I share my view one. In a matrimonial dispute, husband, wife was standing in front of me in a court. I asked that wife, I said, he's your husband? He says, yes, he's my husband. I said, there are thousands of allegations you have leveled against him. Do you rely upon these allegations? And now I'll tell you in brackets. She said, I never said. This is my lawyer who dictated all these grounds. And he told me that if you want to squeeze this man, and unless you corner him within the parameters of law, this man will never come to your rescue. So please, so these are the grounds my lawyer has framed, not me. This was the word of the lady before me. You see, what I want to tell you is, dispute is something very, very minuscule. But when it goes to a court of law, to establish your stand, you just make it a issue which makes into a litigation. I always say, initially when the parties come forward with there is a problem. Problem converts into misunderstanding. Misunderstanding goes into disputes. And disputes could not be resolved in due course of time, that become litigation. So we are facing now a litigation. And if mediation takes a front seat and we go with a positive approach, I'm sure that at the very threshold of where the parties have some personal reservations because of some reasons, can be resolved at that particular stage. And the beauty is, see the beauty of this mediation. You restore relations. Your animosity between the litigant parties is also eroded by passage of time. You restore back your commercial relations. Family get restored. Individuals get restored. Neighbors get restored. Because people say, you can't change neighbor, you can change your friend. You are choosy about friend, but can't be your neighbor. So if you have to be a neighbor, have a good friend as a neighbor. And that is possible only through the process of mediation and not by any other code of law. This is the way by which we all work. And one thing more, in a court of law, you are thrust upon to get your matter disposed of by a particular judge. Whether he know the law, he doesn't know the law, liking, no liking, you are bent upon. But in mediation, you accept a neutral person of your choice. You have a trust on him. You believe that whatever the outcome will come is binding on me. You'll be open to him. You will never come with any reservations. And I'm sorry, we were also lawyers, and one time to time, if pleadings go through lawyers, it has become 100 pages. If a litigant comes himself, the pleading will be running into 5 pages. So 45 pages is addition to bring your matter within the parameters of a section which is statute covers your litigation. That is the way by which we work in the field of litigation. Secondly, I'd like to say, to preserve relationship is only possible by mediation and by no other cause. Arbitration is also an adjudicatory mechanism, not to resolve your preserving relationships. This is only possible by this particular method. For students, I would like to say that please participate with full rigor, openness, put your best, and whosoever is winner, certainly he is congratulated. He will get some kind of mementos also by those who are organizing this function. But those who lose, I'll say they are also not losers. They also get knowledge and experience gained by particular this process. So ultimately, we gain something in the competitive process. And to my understanding, there's no one loser, no one winner. But only to make selection amongst the participants, you have to lay down that who is the better one amongst the all who have participated. That is the way by which we all work. And I further ask for the students that by this competition, you will develop skills in negotiation, conflict resolution, and mediation, which are essential in both our legal practice and real-world problem solving. My congratulations to all participants. Please do your best. And whatever the result is, please accept voluntarily. This is not a game. This is a competition. One must go ahead with the best what is possible. But still, keep yourself within the parameters of the mediation which has been prescribed under law. And now, since the mediation has been institutionalized by the Act of 23, take note of the process of mediation. And last but not the least, and Mr. Chaudhary, Mr. Mahajan, and lawyers who are listening me will accept, parties down the line have a reservation. Sir, the present litigation, whether it is court litigation or arbitration litigation, is very, very cumbersome and not economical to me. I'm also there. I also accept this, what is complained to us. Mediation is one thing which is very effective, efficiency and cost effective. And in a time-bound manner. I think in commercial court or Act of 23, they have said 120 days is the time limit. An extension can be 60 days with the permission. So if we take 60 plus 120, 180 days. So 180 days is the outcome where the mediation has to be finally resolved. And if you go to arbitration with the help of 29A, 18 months is the time. And I'm sorry to say there are applications are being filed by parties or by arbitrators to extension of time in a court. So I think all kind of scenario can be fixed by this mediation process. I once again congratulate all participants to give, and to Mr. Guru, who has given me this opportunity to address and share my views for the process of mediation. Thank you very much once again. Thank you. I'm so thankful.
Thank you so much, sir. I'm
Thank
not
you, sir.
Guru, I'm Mayor.
Thank you,
Govind.
sir, for your detailed explanation of the mediation journey. It provided us with great clarity and insight. And I believe we all agree that from the panchayat system to the institutionalized mediation system, we have come a long way. Now, with that remarkable keynote address, we reach the conclusion of our inaugural ceremony. To formally extend our gratitude, I invite Ms. Garima Rana, Senior Partner at Mediate Guru, to deliver the vote of thanks.
Good evening, everyone. It is my privilege to extend a heartfelt vote of thanks as we come to the end of the inaugural session of the 5th Virtual International Mediation Competition 2025. My deepest gratitude to our Chief Guest, Honorable Justice Mr. Ajay Rastogi, for his presence and insightful words that have set the perfect tone for this competition. A special thanks to Mr. Joe Tirado for sharing his expertise and adding immense value to this platform. I also extend my appreciation to Mr. Praveen Mahajan, Principal Partner at Equilaw Partners, and Mr. Jyoti Kumar Chaudhary, Partner at Hammurabi and Solomon Partners, for the support and collaboration. Their firms have not only partnered with us, but I've also extended a prestigious internship opportunity to the winners, further strengthening their practical understanding of dispute resolution. A special mention to APIIT Law School for their incredible support in providing volunteers whose dedication in ensuring the smooth functioning of this event is very important. To our sponsors, partners, judges, volunteers, and most importantly, participants, thank you for being part of this journey. At its core, mediation is about fostering dialogue, understanding different perspectives, and working towards a collaborative solution. Over the next few days, this competition will challenge you, refine your skills, and expose you to a real world mediation scenario. We hope this experience not only strengthens your advocacy, but also instills in you the value of effective dispute resolution that are vital in today's legal and business landscapes. With this, we officially commence the 5th Virtual International Mediation Competition 2025, wishing all the participants the very best. May this competition be a transformative experience for all. Thank you very much.
And with that, ladies and gentlemen, we conclude the inaugural ceremony of 5th Virtual International Mediation Competition 2025. Thank you all for being a part of this prestigious event. We look forward to witnessing an engaging and insightful competition in the coming days. Let the mediation begin.
Thank you.
Thank you so much, everyone.
Thank you very much.
Thank you so much.
Thank you. Take care.
Thank you. We too.